want to turn this conversation to you, Mr. Charles Jalloh. You specifically addressed this issue in an article you just recently published, where you were quoting or citing Article 17 of the ICC, which particularly addresses the situation before them right now, where it pertains to Kenya.
Yes, first of all, thank you for the opportunity to be on your show.
You're welcome.
Now, going to the question, I think that we have to make a distinction between two issues. One is the legal issue that is at stake when we talk about the way the ICC ought to operate vis-a-vis national jurisdictions, and that is the complementarity principle. Under that principle, it is very clear as a matter of law that the first responsibility to prosecute, to investigate and prosecute international crimes falling within the jurisdiction of the court lies in the national jurisdiction, and in the case of Kenya, in Kenya's hands. Now, the second point I'd like to make, of course, is the point that Mr. Muchokyo made, and that is Kenya was given an opportunity to actually do this under its own domestic system. There were options that were discussed coming out of the WACI Commission report, including the idea of a special hybrid tribunal for Kenya, the so-called STK, which never came into being because, in fact, some members of the Kenyan parliament actually scuttled the process. So at the end of the day, Kenya found itself before the court precisely because there were some actors in the national jurisdiction that were not playing good faith. Having said that, I want to add another point. The way the complementarity principle has been interpreted by the court at the moment is actually very strict. And my argument in my article has been that, in fact, if the court applies the standard that basically says you must be investigating the same person for substantially the same conduct as at the time that the person is before the court, then there is no issue of complementarity because you're not doing something about it. I think that it's as a matter of law, is a correct legal point, but it's a strict legal point that fails to account for the realities on the ground. Because in fact, Kenya did come to the court later, arguing that it wanted sufficient time to make changes to its national system so that it could actually go forward to investigate and prosecute those cases. The court has taken the same position with respect to Libya, and it has taken the same position with respect to the recent decision vis-a-vis Cote d'Ivoire. And I think that a strict approach it would not do well in allowing the court to actually function in a limited set of situations. So as a matter of law, it's correct what the appeals chamber has said, but they ought to be more flexible in dealing with the realities of African countries, especially those caught up in the throes of transition.